Good afternoon, everyone. For your final session of the day, Sophia and I are going to talk about what is ultimately a procedural question, which is how to keep your client's confidential information protected within the litigation process. So this is mainly going to be an issue for claimant ex-employers, but it could also be an issue for defendant new employers, because many business protection claims really have at their heart the issue of confidential information. Commercial information, say, about technical data, products, processes, trading strategies and financial services, business information about fundraising and finances, pricing information and client lists. And in any piece of business protection litigation, claimants are likely to need to engage with confidentiality, as are defendants, in order to deal with the elements of their claims. For example, starting with covenants, looking at confidentiality isn't simply a question of establishing the legitimate business interest that's required to show reasonableness. It goes much further and deeper than that. The courts will need to consider where, for example, there's a lengthy covenant, say a year-long covenant, what the shelf life is of the confidential information. And not just that, the court might need to look at whether the confidential information is memorable, such to justify a long period of restraint. And that can't be done by pleadings and submissions or even just witness statements. What that's going to need is the court to look very carefully, for example, looking at whether something's memorable or not, is how complex, how memorable, portable the confidential information is. Of course, in breach of confidence claims, any element of that will require looking at confidentiality, liability, the need for an order, limitation when it comes to equitable claims. So far as the exercise of discretion is concerned, again, at the point the order is made at an interim stage or even at trial, the court might need to consider, again, the issue of memorability or shelf life. And also, so far as financial remedy is concerned, any claim for an account of profits will need very precise analysis of what the confidential information is and how it's been misused. So parties in litigation of this kind often run the risk that commercially sensitive information will be revealed not just to the other side, but to the world at large. And that can be problematical because all of that bumps up against the open justice principle. Now, the main focus of the open justice principle is really twofold. Firstly, it's there to hold courts and judges to account. Closely related to that, it's there to ensure that the public understand the court process, but also how decisions are made. So I quote there a case which I think it finds its way into almost any set of submissions on this subject, the case of Scott and Scott, where Lord Shaw said, "Publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity." So in the Guardian and Westminster Magistrates case that's referred to there, the Guardian was permitted to inspect and indeed take skeleton arguments that were submitted by the parties in that case, an extradition case. Because a lot of the cases are actually not about commercially sensitive information, but about personal information. A lot of the case law is about allegations made against the applicant for secrecy. But the principle of open justice, of course, applies equally to commercially sensitive information as well. And lastly, one aspect of open justice is that, in fact, a fundamental aspect of open justice is that parties should know the case against them. So what all of this means, a point we'll develop throughout this seminar, is firstly that it's never for the parties to agree any incursion into open justice. Even if the parties agree something, they need to get an order from the court, and that's not something they're going to be granted as of right, even if it's agreed. And secondly, what the court will look for is the minimum possible interference with the open justice principle. So any application for secrecy or privacy in relation to confidential information needs to be proportionate and targeted. So again, any evidence, any submissions needs not only to engage the open justice principle, it needs to really embrace it and explain why a limited derogation is necessary. So I just look next at how open justice operates in practice, which will set up what we're going to say about how one can obtain secrecy. Firstly, under CPR Rule 5.4, court officers may have a publicly accessible register of all the claims issued there. But the point to make here is that not all courts do, in fact, have such a register. There is a register in the RCJ of claims in the King's Bench Division and the Chancery Courts, and indeed the Commercial Court as well. But there is not a register of County Court and District Registry claims, which might be an issue for a particularly publicity-shy client. Because obviously if someone knows that there is a claim there, that can then lead to a train of inquiry to ask for pleadings, skeletons, evidence, and the like. So far as pleadings are concerned, statements of claim are in the first instance available to the public without the permission of the court. So if you want to keep your statements of claim private, away from the prying eyes of the public, you'd need to make an application under CPR 5.C4. And that also applies to orders and judgment. I think in practice, what a lot of litigants do is they have a statement of claim and then some kind of confidential schedule of that, not exhibits, a schedule to the document with confidential information, and call that confidential information and call that confidential. But that isn't a fail-safe way of doing it, because it's arguable that's still part of the statements of claim. So what you'd need to do is make an application under Rule 5.4c. So far as other documents not part of the court records, those would be skeletons, witness statements, other documents referred to in court. Third parties can ask for those, not under Rule 5.4, but under the general principle of open justice. And that's what the Supreme Court case of Cape and Dring was concerned with. It was a third party, an asbestos victims forum wanted to get disclosure about some of the most advanced medical research about mesothelioma, which was disclosed in those proceedings. So the court even then will carry out a balancing exercise between the open justice principle and the need for commerciality. In that case, one can see why that there was a public interest, why it should be open to the public to see evidence of that kind. But if there is genuinely commercially sensitive information and you establish that it is commercially sensitive, then there's every chance you'll be able to protect that from prying eyes. Of course, when you're talking about confidentiality, one of the things you'll be concerned about is giving disclosure in those proceedings. That's obviously whether under standard disclosure under the King's Bench system or the or model-based disclosure in the Business and Property Court. But obviously remember as well that any document referred to in a witness statement or pleading can be disclosed effectively as of right. So one obviously shouldn't refer to confidential documents without protections that we're going to talk about. And of course, interim hearings, trial and judgments are also generally public. And if there's going to be any incursion into the open justice principle in relation to those will need to be addressed. And we're going to talk about those in this session. So just before I hand over to Sophia to talk about how you can protect your information within the process, just talk first of all about keeping confidential information out of the process. So the first point there is you might want to think about the overall shape of the litigation, the scope of it and the overall strategy. It might be that you, as a claimant, have a non-compete covenant that's obviously the gold standard for a restraint. It stops the ex-employee from working, but it needs confidential information to establish it. It may be something to consider in an appropriate case with the clients, whether you actually want that covenant at all, if you have to disclose confidential information to enforce it in circumstances where, for example, you might be satisfied just with a non-solicitation covenant that doesn't need confidential information to justify it. Commercial arbitration clauses are not uncommon in employment contracts in the financial services sector, and confidentiality is one of the many perceived advantages of commercial arbitration. For example, Article 33 of the Rules of the London Court of International Arbitration says that any materials produced, that's disclosed within the process, any documents created for the process, and any awards, that's decision, are all confidential unless the parties want it publicised. So, for example, if you're not going to seek interim relief, which is often carved out of those, that would be a way of avoiding publicity in litigation, which is generally public. And you might also take tactical decisions about whether you want to run particular arguments more generally that engages confidential information. So, for example, an allegation of repudiatory breach, does it need to be, is it worth the price of disclosing confidential information in support of it? And closely related to that, do you need to join the new employer? Because subject to the safeguards that we're about to talk about, in general, they will need to be given disclosure of confidential information. So with all of that, I'm going to hand over to Sophia to talk about interim hearings.
Thank you, Niran. For the reasons Niran set out at the outset of this talk, confidential information is likely to be a key component to any interim application you're making to enforce post-termination restrictions, or, for example, if you're seeking a springboard injunction on an interim basis. CPR Rule 31.221 restricts the collateral use of disclosure in the litigation, but that restriction is subject to a wide caveat, the caveat being that once the disclosure has been read or referred to in a public hearing, that restriction no longer applies. So no restriction on collateral use applies to that disclosure. And that caveat has been held to apply to documents that have been pre-read by applications judges, or to documents that have been even referred to in witness statements put before the applications judge, even in circumstances where the witness statement or the document isn't read out in open court. CPR Rule 32.12 contains a similar restriction on the collateral use of witness statements, but again, that has a similar caveat to it that if the witness statement has been put into evidence in respect of a public hearing, the restriction no longer applies. So you can see that there's very little comfort provided by these CPR restrictions on collateral use, where a client wants to protect their confidential information or trade secrets within the interim application process. So you might want to consider how you go about protecting documents that you might have put in a confidential exhibit or witness statement in support of your interim application. And one thing you might seek to do is make an application under Rule 31.22(2), which allows for an order prohibiting or restricting the use of disclosure which has been put to the other side in the litigation. But as Niran has said, all such applications are subject to the open justice principle. And it's not always the case that the court will grant these types of orders. So we've put down the case of HTC Corporation and Gemalto on the slides. that was a case where an application was made for an order under CPR Rule 31.22.2, and it wasn't granted in respect of all categories of documents. Essentially, the client had overreached itself by applying for that protection on collateral use in respect of documents that were several years old, emails, a business plan that were rather out of date. So it might be that you need to manage the client's expectations in respect of what can be achieved through these rules and what information can truly be protected by the court in the interim injunction process. The application for an order under CPR Rule 31.22(2) can, however, be held in private, and that is made clear in the guidance to that provision within the White Book. Looking at private hearings themselves, these are really a very severe limitation on the open justice principle, and the court is unlikely to grant them except in the most exceptional cases where no other restrictions short of a private hearing are going to be sufficient to protect the confidential information of the client. But CPR Rule 39.23c does provide that private hearings can be granted in cases where confidential information is an issue and where publicity would damage that confidentiality. And we can all think of precedents within the business protection sphere where interim hearings and final hearings have been held in private. Dyson and Pellery is such an example. It went to the Court of Appeal. At the final hearing in the High Court, the matter was heard in private. But as I've said before, the starting point is the open justice principle, and that this is a severe incursion, and your witness evidence in support of that application will need to deal with why you say nothing short of a private hearing will be sufficient to protect the client's position, why you say that this would have an impact that wasn't too severe on third parties, because the court will also be considering, well, what impact does this have on third parties that wish to report on the application or hear the application. And so whilst there are precedents, this is the most severe restriction on open justice, and the court will scrutinise the application very carefully, hence good preparation is required to make it. I'll now hand back to Niran to discuss confidentiality clubs.
So the purpose of a confidentiality club or a confidentiality ring is to stop documents being used outside the litigation process. The starting point, of course, is CPR Rule 31.22, which provides that parties are not to use documents for any purpose other than the litigation. But of course, courts recognise that either deliberately or inadvertently, parties still sometimes need protection, and the protection of a confidentiality club. Terms being that the documents are disclosed to the other side on conditions such as when and where they're going to be viewed by the parties. So, for example, can they only be viewed at the solicitor's offices? Terms could be how the information is held on a document management system, any broader conditions such as being destroyed afterwards. But in all of this, and the scope of this talk doesn't we're not going into detail of looking at precise terms, but in all of this, any terms in a confidentiality club need not only to be proportionate, but practical. So there are going to need to be exceptions to the restrictions for trial preparation. So, for example, it might be that documents should only be viewed on a document management system, but the parties may be able to have copies of, in hard copy or electronic, of, say, their draft witness statements or be shown draft correspondence. One of the observations of Mr. Justice Roth in the Infederation case that's referred to there is that parties sometimes make excessive claims for confidentiality in a confidentiality club, a lot of documents in, very stringent terms, but those are then curtailed or renounced in response to protests from the other side or intervention by the court. The judge went on to say that was not the way modern litigation should be conducted. So it's highly important when agreeing the terms of a confidentiality club not to overreach. Again, that's not the way you're supposed to conduct litigation. But equally, I think it's important not to underreach as well. If you've asked for too little and the other side are going to see information of a particular kind or on certain terms, it might give rise to a submission against you. Well, if they can see that, then why can't they see everything? So all of this needs very careful consideration and indeed early consideration. Now, in the business and property courts, there's the disclosure review document. That's an obvious time to consider the need for confidentiality club, but the same might be true in the King's Bench division as well. Just think early, before disclosure, about the terms of a confidentiality club. Because in all of this, it gets harder to seek confidentiality the closer that you get to trial. And one reason for that is that there will be orders that are running throughout the whole process. So, for example, if you give disclosure, but you haven't agreed the confidentiality club at that point and hold back on your disclosure in the hope you're then going to agree the terms of a confidentiality club later on, there's a problem because you'll effectively have been in breach of the disclosure order. And what you'll be asking for is not only the terms of a confidentiality club if you have to go to court, but you'll also be seeking relief from sanctions, and you'll be needing to comply with the Denton requirements, where the court assesses the seriousness of the non-compliance and the reason why the breach occurred. So all of this points to dealing with these issues at the earliest stage. When it comes to who's inside the confidentiality ring, if there are individual as opposed to corporate defendants, they will really need to see all the confidential documents, even though they're probably the people who the claimant least wants to see them. Confidentiality rings are really about corporate defendants. And in that context, it's worth noting what was said by the court in the Anand Kasai case, which was a patent case, as many of the cases in this area are, which is the court should be slow to second-guess the choice of the person that the party wants inside the confidentiality club. There's a deference the court gives to what the party says about the need to take instructions from a certain person. And in that case, the court said, against the wishes of the other party, that the CEO of the company needed to see the documents. OnePlus is a case where the court went the other way. It found that the particular in-house lawyers didn't need to be inside the confidentiality club. But the precise terms and who's in and who's out, and on what terms, depends really largely on the organisation of business and the extent to which a party can say there's someone else who isn't commercially involved in the information who can give instructions in relation to it. Many claimants will want external eyes only terms of a confidentiality club. That is to say, they will only want the lawyers or potentially experts to see the documents. As stated in OnePlus and many other cases, such orders are exceptional. But having said all of that, if you get in early in relation to this, it may be that you can agree the terms of a wider order that can be then approved by the court. And then if there are documents which are not going to be viewed at trial or thought not to be relevant or need to go in the trial bundle, then you can look again at confidentiality later on. And similarly, there might be tiers or rings within the confidentiality ring where more confidential documents are subject to more stringent terms. But again, all of this points to early and careful consideration of what documents which parties should be inside the ring. I'm just going to say something about redaction of documents. Documents can be redacted if the information in them is both confidential and irrelevant. So confidentiality is not enough. Privilege is enough, but not confidentiality. And we're all used to seeing swathes of documents in disclosure with line after line, page after page blacked out. And the only point I want to make in relation to this is that you don't need to accept that. The court recognises that parties can be over-enthusiastic, and there are mechanisms to challenge that. Under Practice Direction 57 AD, redactions must be, first of all, explained. The basis on which the redaction is made needs to be explained, but also the legal representative with conduct of the litigation needs to confirm that they've reviewed the redactions. And again, that only applies under Practice 57 AD, but in general, seems to be a legitimate principle to apply in all litigation where redactions are concerned. And what the courts have repeatedly emphasised is that the duty of solicitors in relation to redaction is similar to the role generally, that duty is generally in relation to this disclosure. There's no difference in principle between the ambit of the solicitor's duty in the conduct and supervision of disclosure and in the conduct and supervision of any redaction. And the courts have highlighted relevant duties in federation. They referred to an EC case and referred to a rebuttable presumption that the documents more than 5 years old were no longer confidential as a guide to the extent of justifiable confidentiality. It's also in that case, they said that if the client's claims to confidentiality justifying redaction were excessive, that in those circumstances, it was a duty of the solicitor to challenge that. Because if a party is not happy with the scope of the other side's redactions, it can make an application to the court. And what the court can do is require the disclosing party, in fact, their legal advisors, to swear an affidavit explaining the basis of redaction, not just confirming they've done it, but explaining the basis of that. And if the court's unhappy with that, what the court can do is look at the confidential documents itself in a private hearing. But again, all of this points to doing this early and carefully rather than leaving it to near trial. I'm just going to hand over lastly to Sophia to talk about confidentiality at trial.
The main message we want to convey with this slide is that you shouldn't leave thought about what protections your client's confidentiality needs at trial to the last minute. Don't be the hapless canoeist in this cartoon. Think ahead about what is required to protect your client's trade secrets or confidentiality. Seek the other side's agreement to measures that will protect it, and leave enough time that if you can't agree or you need to make an application, you can do so, and that it's well thought through and has proper evidence in support of it. Mr. Justice Burse, for example, in the Hospira case, said it was very inconvenient to have to deal with this type of an application at trial, in the middle of trial, and you don't want to get your judge on the wrong side at the outset of a final hearing. The orders that we've suggested on this slide are all ones that were actually applied for in the jump litigation, in which Niran and I, along with our colleague Asfandia, appeared for Mr. Couture, the former employee. As you can see, the draft orders that were sought to protect the alleged confidential information of the former employer were targeted both at protecting that alleged confidential information during the hearing, so for example by prohibiting it being read out within open court, and also protection from it being accessed by third parties, for example, requiring any application to be made on notice to the claimant. There are, of course, other measures that you might seek to protect your client's confidential information within the trial process, for example, restricted reporting orders or anonymity orders. And you might also need to think about how that confidential information might work its way through into the judgment as well. Of course, all these applications need to be balanced against the incursion on open justice that they constitute. And they also have to be thought about in the context of what amounts to a fair trial. So hence why you might want to try and agree a procedure with the other side that allows confidential information to be referred to during cross-examination submissions, but without that the nature of that confidential information being revealed. And that's what we're referring to with the word cipher within the slide. So careful thought is required, and our 3 takeaway points from this talk are to think about these matters at an early stage with counsel, seek to agree restrictions with the other side early on in the procedure. As Niran says, the closer you get to trial, the harder these things are. And be targeted and proportionate in your applications, giving full regard to the open justice principle, which is always going to be the starting point for the court hearing your application. Thank you.